The Wike-Fubara war is over. The peace deal is signed. The 2027 candidate lists are being uploaded to INEC. Most Nigerians believe the crisis ended when Fubara withdrew from the APC primary in May 2026. They are wrong. The crisis produced 5 legal precedents that are now permanently embedded in Nigerian constitutional jurisprudence. 5 rulings across 3 levels of the court system that every politician, every election tribunal, every future governor, and every voter will live with in 2027, and for every election after it. None of these precedents were declared finished when the political war ended. They are still binding, they are still cited, and in at least one case, legal scholars at the highest levels of the Nigerian bar have argued that the ruling that produced it should never have been made at all, because a 5-member Supreme Court panel cannot legally overrule a 7-member Supreme Court panel from 2015. While everyone is focused on who is on the 2027 ballot, nobody is examining what the legal architecture of that ballot has become, what the Fubara crisis permanently changed about how courts will handle election disputes, how governors can be removed, how state budgets can be frozen, and how far a sitting president's emergency powers can reach into a state government. That architecture is what this video is about, and it matters to every Nigerian. Before we name the 5 precedents, we need to establish what a legal precedent actually is and why it matters beyond the immediate political dispute that produced it. In Nigeria's common law system, a decision by a higher court on a point of law is binding on every lower court facing the same question. A Supreme Court ruling does not simply resolve the dispute before it. It becomes the authoritative statement of what Nigerian law means, permanently, until the Supreme Court itself overrules it in a future case. The Fubara crisis was not just a political war, it was a legal laboratory. Every decision made by the Supreme Court, the Court of Appeal, and the Federal High Court in the Rivers State disputes between 2023 and 2026 is now part of the body of law that will govern how similar situations are handled in the future. Legal scholars examining the Rivers State decisions have identified what they call a dangerous precedent pattern, rulings that resolve immediate political problems while creating constitutional vulnerabilities that are far more consequential than the original dispute. The 5 precedents this video examines are not theoretical. They are already being cited in pre-trial arguments by lawyers preparing election petition cases for the 2027 cycle. Understanding them is not a legal exercise, it is civic self-defense. Hold this question. The most consequential precedent from the Fubara crisis, the one that legal scholars say should never have been set, was produced by a 5-member Supreme Court panel, but the existing law on the same question was set by a 7-member Supreme Court panel in 2015. In the hierarchy of Nigerian judicial authority, can a smaller panel overrule a larger one? I will give you the complete answer in Act 3. Stay with me. 5 specific legal precedents emerged from the Fubara crisis, named precisely, not summarized. Precedent 1. The CBN allocation freeze. The Supreme Court ordered the Central Bank of Nigeria and the Accountant General of the Federation to stop releasing federal allocations to Rivers State government until Fubara complied with its orders. This is the first time in Nigerian constitutional history that the Apex Court used a state's federal allocation as a compliance enforcement weapon. It is now precedent. Any future state government in sustained non-compliance with a Supreme Court order is legally exposed to the same instrument. Precedent 2. Section 308 immunity cannot protect unconstitutional acts. The Supreme Court found that Fubara used his executive immunity under Section 308 of the Constitution to carry out barbaric acts against the rule of law. The court found that immunity protects a governor from criminal prosecution. It does not shield him from judicial findings about unconstitutional executive acts. That distinction between immunity from arrest and immunity from constitutional accountability is now settled by the Apex Court. Precedent 3. Section 305 Emergency Rule covers political governance breakdown. President Tinubu's declaration of a state of emergency in March 2025, which suspended an elected governor, was contested as unconstitutional by the NBA, senior advocates, and multiple legal scholars. It was ratified by the National Assembly. No court definitively ruled it unconstitutional before its expiration in September 2025. Its political survival without a successful legal reversal means it has established a practical precedent. Emergency rule can be invoked and applied in a political governance dispute, not just a security crisis. Precedent 4. Section 188 has no bar on repeat invocations. The impeachment provision was invoked against Fubara 3 times between 2023 and 2026. 0 completions, 0 verdicts. No court found that the repeat invocations themselves were unconstitutional. The silence of the courts on this question means there is no established prohibition against using Section 188 as a perpetual threat mechanism, initiated, suspended, and reinitiated without resolution. Precedent 5. LGA elections cannot be conducted without a 90-day notice. The Supreme Court nullified the October 2024 Rivers State local government elections for violation of Section 150 of the Electoral Act, specifically because RSIEC failed to comply with notice and procedural requirements. This reaffirms a hard procedural threshold. No subsequent events can cure the procedural defect. An election conducted without proper notice is void regardless of the result. The mainstream media covers the noise, but on this channel, we track the actual chess moves building up to 2027. If you want to understand how power really shifts in Nigeria before it breaks on the news, hit that subscribe button right now and turn on notifications. Let's look at how the rules are being manipulated. Here is the legal controversy that the Nigerian bar has been debating since February 2025 and that almost no political commentary has explained to ordinary Nigerians. The Supreme Court ruling of February 2025, which reinstated the 27 Amaesule Mako lawmakers, ordered the CBN to freeze Rivers State's allocation and nullified the October 2024 Rivers State local government elections, was decided by a 5-member panel of justices. On the same question of defection and legislative seat forfeiture, the Supreme Court had previously ruled in the case of Abigunde versus Ondo State House of Assembly in 2015. That ruling was decided by a 7-member panel. A fundamental principle of judicial precedent established in Nigerian and Commonwealth jurisprudence is that a smaller panel of judges cannot overrule a larger panel within the same court hierarchy. As Professor Chidiodin Kalu stated publicly, a 5-person panel of the Supreme Court cannot overrule a 7-person panel. The February 2025 ruling reached conclusions that conflicted with or distinguished the 2015 Abigunde ruling, but it did so with a panel 2 members smaller than the one that produced the original binding authority. The implications of this are specific and serious. The principle exists to ensure consistency, stability, and credibility in legal rulings. When a smaller panel issues a decision that effectively displaces a larger panel's authority on the same question, it introduces instability into the body of law, because the original larger panel ruling is technically still binding on all lower courts until and unless a full panel of the Supreme Court revisits it. What this means practically for 2027 election disputes: any lawyer arguing a case about legislative defection, assembly composition, or seat forfeiture has a legitimate basis to argue that the February 2025 5-panel ruling cannot displace the 2015 7-panel Abigunde decision. That argument has not been resolved. It is available. And in election petition proceedings where a single legal point can determine an outcome, an unresolved panel-size conflict at the Supreme Court level is not a technical footnote, it is a litigation weapon.
The decision has weakened public trust in the judiciary, creating instability in democratic governance. The whole of Nigeria is bound by the decision and will continue to live with it until and unless the Supreme Court, sitting in a larger panel, reverses it. Now, if the political strategy I just laid out surprises you, drop a comment below with your thoughts right now. I read every response, because we are about to pivot to the national fallout that changes everything.
The 2027 election cycle will produce election disputes. That is not a prediction, it is a certainty established by every previous Nigerian election cycle. What is different about 2027 is that the legal architecture of those disputes has been reconfigured by the Fubara crisis precedents in 5 specific ways. First, any governor who defies a court order during a political dispute now faces the CBN freeze precedent. A future opposition governor who refuses to comply with an unfavorable court ruling on assembly composition, on budget appropriation, on local government elections faces an established precedent that the apex court can order the federal government to cut off his state's allocation until he complies. That instrument did not exist before 2025. It exists now. Second, emergency rule is now available as a political governance intervention tool. The NBA warned explicitly that the Section 305 declaration set a dangerous precedent for executive overreach and undermined the separation of powers. That warning is valid regardless of what one thinks about the specific Rivers State situation. A future president who wants to intervene in a state with an opposition governor on the pretext of governance breakdown now has a practical precedent that survived without a successful legal reversal. Third, the repeat Section 188 pattern is legally available everywhere. Every state with a governor from one party and a legislature from another, or with a factionalized majority, now exists in a legal environment where impeachment notices can be filed, withdrawn, and refiled indefinitely. No court has said this is impermissible. Lawyers planning political strategy for 2027 governorship races in competitive states are reading the Fubara precedent as a governance harassment instrument. Fourth, LGA election timing is now strictly enforced. The 90-day notice requirement is no longer a procedural suggestion. It is a judicially enforced threshold. Any state government that attempts to conduct local government elections without the full statutory notice period for any reason, however politically convenient, will face nullification. Fifth, the 5-panel versus 7-panel conflict creates litigation uncertainty on defection cases. Any 2027 election petition involving legislative defection, party membership disputes, or assembly composition will be fought partly on the question of which Supreme Court precedent applies. That uncertainty benefits litigants who can afford prolonged legal battles and disadvantages candidates with fewer legal resources. Taken together, these 5 precedents constitute what this channel is calling the Fubara Doctrine. Not because Fubara designed it, but because the crisis he was at the center of produced it. A set of legal instruments that, in combination, can be used to freeze a state's finances, suspend an elected government, paralyze its legislature indefinitely, and contest any local election that was conducted without precise procedural compliance. The Fubara Doctrine is binding law today. It cannot be unmade by a political resolution or a peace deal. It can only be changed by constitutional amendment, by a future Supreme Court sitting in a full panel, or by statutory reform that closes the gaps the crisis exposed. 3 reforms are specific, achievable, and urgent before January 2027. Reform 1. The National Assembly must define governance breakdown in Section 305 with statutory specificity. Emergency rule should not be legally available in a political dispute about which lawmakers may sit in an assembly chamber. The Electoral Act amendments being debated in the 2026 session are the correct legislative vehicle for a Section 305 clarification rider. The National Assembly should either pass that rider before the September campaign season begins, or the next opposition governor in a federal confrontation will have no constitutional protection against the same instrument. Reform 2.
the Supreme Court should schedule a full panel review of the 5-member versus 7-member conflict. This is within the court's own administrative authority. The principle that a smaller panel cannot overrule a larger one is not just a procedural nicety, it is the foundation of legal consistency. A full Supreme Court panel should sit, revisit both the 2015 Abegunde ruling and the 2025 Rivers State ruling, and issue a single authoritative statement on the law of legislative defection. Until that happens, every defection-related election petition in 2027 will be fought in the shadow of an unresolved contradiction at the apex level. Reform 3. INEC must publish binding guidelines on the CBN freeze precedents procedural safeguards. The 2025 Supreme Court ruling gave no guidance on what process a state government must follow to challenge an allocation freeze, how quickly a compliance determination must be made, or what safeguards protect against the instrument being triggered by politically motivated litigation. INEC cannot make the Supreme Court set these safeguards, but it can publish before September 2026 its own administrative protocols for handling candidate submissions and electoral processes in states where federal allocation disputes are active, so that future election tribunals have a reference framework. I asked you at the start whether a 5-member Supreme Court panel can overrule a 7-member panel. The answer, under established Nigerian and Commonwealth jurisprudential principle, is no, it cannot. But the February 2025 ruling exists, it is on record, it is being cited, and because no subsequent full panel has convened to resolve the contradiction, both rulings are simultaneously in the law. That is the Fubara Doctrine's most lasting and most dangerous legacy. A jurisprudential ambiguity at the apex level about who can sit in a legislature that every election tribunal, every legal team, and every political actor in 2027 will exploit or navigate according to their interests.
The Fubara crisis ended politically in May 2026. It did not end legally. The 5 precedents it produced, the CBN freeze, the Section 308 immunity limitation, the Section 305 political emergency, the infinite Section 188 invocation pattern, and the 90-day LGA notice rule are binding on every court in Nigeria. They will be cited in 2027 election disputes. They will be deployed by political actors who understand their reach, and they will affect governance outcomes in states that have nothing to do with Rivers State. The Fubara Doctrine is not a personal legacy. It is a legal infrastructure built through conflict, tested through crisis, and now embedded in Nigerian constitutional law without deliberate design and without public consent. For ordinary Nigerians, this matters in a specific way. Your vote in 2027 will be counted and declared, but whether that declaration holds, whether it survives the legal challenges that will follow, depends on a body of precedent that you did not vote for, cannot petition, and cannot easily understand without the kind of analysis this channel exists to provide. The courts are not finished with the Fubara era. They are just beginning to feel its weight. We are building the most politically informed community for Nigerians at home and across the diaspora. If this analysis gave you absolute clarity, share it with one person who needs to see it. Hit subscribe right now so you don't miss our next major upcoming breakdown, where we expose how the 5 Fubara Doctrine precedents are already being used by legal teams preparing 2027 election petition strategies, and which states and governorship races are most legally exposed. Like the video, subscribe, and I will see you in the next analysis.